you, Mr. Chair. Senator Tillis, if you would have taken a few more minutes, and I would have had more time to ask more questions as
I'm
well.
happy to ask another question,
I'll
too.
do some follow-up in writing. Good afternoon. Let me begin by thanking Chairman Coons for holding this hearing. We're here to speak about foreign threats to American innovation. But I'd be remiss if I didn't acknowledge a couple of areas where we're actually doing harm to ourselves. First, we need to do more to ensure that our innovation ecosystem is welcoming and reflective of the creative capabilities of all of our communities, even within the United States. There are some communities, some populations that are very active and represented in innovation, and others that we have, by a long shot, not begun to tap the talent, the creativity, and future expertise and leadership. We also need an immigration system that allows us to much more effectively not just recruit talent, but retain talent. And that may be a worthwhile topic for a hearing another day. I do want to jump into a specific item that I don't think gets as much attention as it deserves, and that's our efforts to fully understand the avenues that nation-state actors are using to take advantage of patents and our legal system. I think it's essential to identifying systemic vulnerabilities. For example, it can be difficult to identify the direct financial interests at play in patent infringement litigation. What do I mean by that? Well, let me just say I'm concerned that the funding obfuscation may be shielding nation-state conduct that is meant to harass American firms or attempt to force the disclosure of sensitive information. So let's start with Professor Cohen. Do we know whether or how much, not just the Chinese government, but any foreign government for that matter, funds or subsidizes patent infringement litigation against American firms?
Thank you, Senator. If I may back up a little bit, I think we don't even know how much foreign ownership and investment there is in our patent and trademark applications. So the underlying rights themselves are not identified if there is a government subsidy or support. We do require that in Bayh-Dole. If there is a U.S. government-funded patent application, then that would be disclosed and available on the PTO database. That does not apply to foreign applicants. So I also think this is particularly critical. It's caused a lot of disruption in the PTO with government subsidies from China of trademark applications, and I think a disclosure requirement could be immensely helpful, at least in identifying the magnitude of the risk. I do not think we have that data available for government-funded or subsidized patent assertion entities, whether they're from China or elsewhere. And I think that would also be useful, again, in determining the risk, although I doubt that private entities have to disclose the nature of their investors either. I would like to begin really with the right themselves, personally. I think that's a very high priority because patents, as you mentioned, can be an agent of influence in our system, and right now there is no disclosure requirement.
All right, so it sounds like you do agree that it would be helpful,
yes,
valuable to have this information. And if so, any other ideas or recommendations that you would urge Congress to consider?
I think disclosure of Chinese or foreign government investment or support for the underlying research or the application itself, if it's a patent or trademark, will be extremely useful.
Okay. Mr. Kilbride, you seem eager to add here.
Thank you, Senator. I would just agree that we're concerned about the problem. In my case, I'll refer to foreign investment in U.S. litigation, so problem of third-party litigation financing. And while we don't have good numbers to attach to that, I think there's an increasing anecdotal body of evidence that we need to get our hands around it.
Okay. And if the chair would indulge me, I'd like to add just one more question, and that's regarding economic espionage and trade secret theft. This is something that Senator Tillis raised a few minutes ago. The Department of Justice last year announced a shift from its earlier China initiative to a broader strategy for countering nation-state threats. In announcing that change, Assistant Attorney General Olson cited both concerns about threats from other countries, including Russia, Iran, North Korea, as well as concerns from the civil rights community that the China initiative fueled a narrative of intolerance and bias. At the same time, he stated the government of China stands apart in threatening U.S. security through its considered use of espionage, theft of trade secrets, and other tactics to advance its interests. What policy approaches would enable Congress to try to prevent foreign entities from gaining too much access to U.S. intellectual property and technical know-how while still fostering beneficial international research and business collaborations? And again, we'll start with Professor Cohen.
Research integrity is a critical issue, particularly vis-a-vis China. I think in the past it had not, inadequate attention had been paid to that, and that includes not only the ongoing research itself, but the follow-up research. An example of that is China permits the filing of patents anonymously. So in some cases, a trade secret could be misappropriated, and then the misappropriator can take it to China, file a patent anonymously, and the underlying technology is thereby disclosed. Sort of a double whammy. You own the technology that you've stolen, and it's publicly disclosed. So there are some issues we really do need to take up with China in terms of the environment, which sometimes does not foster legitimate technology cooperation. We had some improvements. We brought a WTO case on China's technology transfer rules, which discriminated against foreigners. But a lot of the integrity issues are really going to be left to the universities and companies that undertake them, and imposing higher standards, including best practices for separating out of technology, who gets cooperated, vetting of parties we collaborate with. China is leading the way in many areas is leading laboratories and other facilities. So not engaging with China in certain areas could impair our technological competitiveness and has to be factored in as well.
Thank you very much. Thank you, Mr. Chair.